The shocking truth behind federal sentencing. Guidelines unveiled. Have you ever wondered how federal judges determine sentences for notorious drug traffickers, high-profile fraudsters, or white-collar criminals? The answer lies in the mysterious world of the federal sentencing guidelines, a complex system shrouded in secrecy and riddled with hidden nuances. The federal sentencing guidelines were established by the Sentencing Reform Act of 1984, in response to concerns about disparities in federal sentencing practices. Initially, the guidelines were mandatory and judges were required to sentence someone within the prescribed ranges, but, in 2005, the Supreme Court found this practice to be unconstitutional. Now, courts are obligated to consider the guidelines but may impose sentences above or below the recommended ranges. The process of calculating sentencing guidelines involves several steps, as detailed below. First, determine the base offense level. Each federal crime has a corresponding base offense level, which serves as the starting point for the guidelines calculation. The sentencing manual has an index listing the various federal crimes and associated base offense levels. The second step is to identify any specific offense characteristics. The guidelines often indicate certain factors that can increase or decrease the offense level based on the unique circumstances of the case. Third, adjust for victim, role, and obstruction. The guidelines provide for adjustments based on victim-related factors, the defendant's role in the offense, and any attempts to obstruct justice to the extent that these factors are not accounted for elsewhere. For example, was a drug defendant the leader of the organization? Did the white-collar defendant abuse a position of trust to carry out his scheme? Was the victim elderly or disabled and particularly vulnerable? These are all scenarios that can increase a person's guidelines range. Fourth, you will determine the criminal history category. The defendant's criminal history is assigned a category ranging from I, least serious, to V, most serious. This category is determined by assigning points for prior convictions and grouping those points into categories. Next, you can refer to the federal sentencing table to find the recommended guidelines range for a particular offense level and criminal history category. The guideline range is referenced in terms on months. Last, the court will determine whether any departures or variances are applicable that would justify a sentencing outside of the recommended guideline range. Departures are based on factors enumerated in the guidelines, while variances are based on the statutory sentencing factors under 18 U.S.C. Section 3553A. Common base offense scenarios for drug and fraud cases. In drug cases, the base offense level is primarily determined by the type and quantity of the controlled substance involved. The drug quantity table assigns offense levels based upon the substance involved, its quantity. Obviously, penalties increase for the more drugs involved and the perceived dangerousness of the drug. For example, a case involving a small amount of marijuana may result in a lower base offense level, while a case involving a significant quantity of heroin or fentanyl would yield a higher level. The drug guidelines also provide for a drug equivalency table. This table is used to convert quantities of different types of drugs into their marijuana equivalent, which is then used to determine the offense level. The purpose of this table is to provide proportional penalties when a case involves multiple substances by converting its perceived potency to an equivalent harm associated with marijuana. Many people are critical of this table as there does not appear to be an empirical relationship equating the potency of one substance into a similar potency level of marijuana. Additionally, with the recent trend towards legalization of marijuana and a recognition of its health benefits, equating cocaine and methamphetamine to a legalized substance seems bizarre. In fraud cases, the base offense level is determined by the monetary loss caused by the offense. The guidelines include a loss table that assigns offense levels based on the amount of money involved, with higher levels for larger losses. Factors such as the number of victims, the sophistication of the scheme, and whether the defendant abused a position of trust may also impact the offense level. It should be noted that it isn't just the actual loss to the victims that is measured, as the guidelines require the assessment of an intended loss amount. For example, in a credit card fraud case, the available balance on the card may be the loss amount instead of the total amount of the fraudulent transactions. Similarly, in healthcare fraud cases, The amount billed to Medicare as opposed to what Medicare actually paid the provider is deemed to be the loss amount under the sentencing guidelines. How criminal history points are determined and how the criminal history category is calculated. Criminal history points are assigned based on the defendant's prior convictions and other relevant factors. Points are typically assigned as follows. 1 point for each prior sentence of more than 60 days but less than 13 months. 2 points for each prior sentence of at least 13 months but less than 24 months. 3 points for each prior sentence of exceeding 24 months. 2 additional points if the defendant committed the instant offense while under any criminal justice sentence, such as while out on bond for another crime or on probation. 1 additional point for each prior sentence resulting from a conviction of a crime of violence that did not receive any points because such sentence was treated as a single sentence. This provision is limited to a total of 3 points. The total number of points determines the criminal history category, which ranges from I, least serious, to V, most serious. It should be noted that never every conviction counts towards a person's sentence for purposes of calculating a person's criminal history. Minor or traffic offenses may not be counted and some convictions are simply too old to be counted. Mandatory minimums, statutory maximums, and mechanisms for leniency. In federal sentencing, mandatory minimum and statutory maximum penalties play a critical role in determining the boundaries of a defendant's potential sentence. Mandatory minimums establish a fixed minimum sentence that a judge must impose for a specific crime, effectively limiting the judge's discretion in imposing a lesser sentence. Regardless of the recommended guideline sentencing range, a court is required to impose a mandatory minimum sentence whenever it's applicable. In these instances, the recommended guidelines range will become the mandatory minimum sentence whenever the guidelines suggest a lower sentence. Conversely, statutory maximums set an upper limit on the sentence that a judge may impose for a particular offense. Whenever the recommended guidelines exceed the statutory maximum penalty, the maximum penalty will become the recommended sentencing range. While these sentencing boundaries are generally rigid, certain mechanisms exist that empower courts to go below mandatory minimum sentences under specific circumstances. Safety valve. As mentioned earlier in the article, the safety valve provision, 18 U.S.C. section 3553, F, allows for a sentence below the mandatory minimum for certain non-violent, first-time drug offenders who meet specific criteria. This mechanism is designed to ensure that low-level, non-violent offenders are not subject to unduly harsh sentences. It is important to keep in mind that the mere possession of a firearm during the course of the offense will prohibit safety valve consideration. Additionally, there is a requirement that the accused sit down with investigating officers and provide a truthful explanation of their role in the prosecuted offense regardless if the defendant has entered into a cooperation agreement with the government in order to qualify for the safety valve. Substantial assistance. Under both the sentencing guidelines and statutory law, a court may impose a sentence below a mandatory minimum if the defendant provides substantial assistance to the government in the investigation or prosecution of another person involved in the offense or other known criminal activity. This reduction is granted at the request of the government, typically in the form of a motion, and the extent of the reduction depends on the nature, extent, and significance of the defendant's assistance. The substantial assistance departure, known as a 5K motion, technically only applies to a reduction of the applicable sentencing guidelines and still subjects the offender to a statutory minimum sentence, though, in some jurisdictions, 5K serves as a colloquialism for a recommended sentence below a statutory minimum. But, the correct name for this motion is a 3553E motion, which is the recognized method for a court to vary below a mandatory penalty. Common departures and variances in federal sentencing. Some common departures not previously discussed include aberrant behavior. A downward departure may be considered if the defendant's criminal conduct was a single instance of aberrant behavior without significant criminal history. Criminal purpose. An upward departure may be warranted if the defendant's criminal history category does not adequately reflect the seriousness of the defendant's past criminal conduct or the likelihood of future criminal conduct. In addition to departures, judges may also consider variances from the guidelines range. Variances are based on the statutory sentencing factors under 18 U.S.C. section 3553A. and may be either upward or downward. Some common variances include family ties and responsibilities. A defendant's family situation, such as being a primary caregiver for minor children or having significant family support, may justify a downward variance. Employment history and community involvement. A defendant's stable employment history or active involvement in the community may support a downward variance. Post-offense rehabilitation. If a defendant has made significant efforts toward rehabilitation after the offense, a downward variance may be warranted. Disparity between co-defendants. If there is a significant disparity in the sentences of similarly situated co-defendants, a variance may be considered to address this disparity. The pre-sentence report and filing objections. The pre-sentence report, PSR, is a crucial document in the sentencing process. It is prepared by a probation officer and provides a detailed account of the defendant's background, offense conduct, and other relevant information. The PSR also includes a preliminary guidelines calculation, which forms the basis for the sentencing recommendation. Both the prosecution and defense have the opportunity to review the PSR and file objections to any factual inaccuracies or guidelines calculation errors. Once a party files an objection, the probation officer will file an addendum to the pre-sentence report and other concur with the objection and adjust their calculation accordingly, or they will oppose the objection and provide a written basis for their position. Typically, any unresolved objections are addressed the morning of sentencing. Even if an objection is overruled, the basis for that objection could be useful in arguing for a downward variance on similar grounds. Preparing for the sentencing hearing. Adequate preparation for the sentencing hearing is essential for presenting the best possible arguments and evidence in favor of your client. Here are some key steps to effectively prepare for the sentencing hearing. Prepare for the pre-sentence interview. It is imperative that your lawyer attend this meeting and do not withhold anything back. Often, offenders are embarrassed to discuss physical or sexual abuse and want to deny any substance abuse. However, these stressors could open the door for some leniency at sentencing. This document will serve as a basis for the court's sentence and will follow the offender to the Bureau of Prison as it helps determine what rehabilitative programming is available. Review the pre-sentence report. Carefully review the PSR and identify any factual inaccuracies, guidelines calculation errors, or other issues that need to be addressed. File objections. Submit well-reasoned objections to the PSR, addressing any issues identified during the review process. Your attorney should cite specific guidelines, application notes and case law in support of the objection whenever sustaining the objection impacts the guideline calculation. Gather mitigating evidence. Collect evidence that supports a downward departure or variance, such as letters of support, proof of rehabilitation efforts, or documentation of extraordinary family circumstances. Prepare the defendant. Ensure that the defendant understands the sentencing process, the potential outcomes, and the importance of presenting themselves in a favorable light. Encourage the defendant to express remorse and accept responsibility for their actions. Review the annual and special reports from the Sentencing Commission. The USSC is a treasure trove of information that can help at sentencing. For example, they have reports documenting which crimes result in downward variances more often than others, which crimes or which type of defendant has a lower recidivist rate. The court will appreciate a well-reasoned argument for a variance that is empirically supported by the sentences imposed throughout the country for similarly situated defendants. Develop a sentencing memorandum. Prepare a comprehensive sentencing memorandum that outlines your arguments for a more lenient sentence, cites relevant case law, and presents the mitigating evidence. By following these steps, you can effectively advocate for your client at the sentencing hearing and increase the likelihood of a favorable outcome.